This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why it is improper to conceal from an insurer prior acts of sexual abuse, because those prior acts will almost always be excluded from a liability insurance policy for anyone involved in the business of insurance or in the business of purchasing insurance, and why one should never lie or conceal potential claims from an insurer, because every application for insurance must provide the absolute truth to the insurer. Plaintiff CMGK LLC, doing business as Massage Envy, appealed from an order granting summary judgment to defendant certain underwriters at Lloyd's London subscribing to a policy number ME10XXX and dismissing with prejudice plaintiff's claims. Plaintiff sought coverage under a sexual acts liability endorsement of a claims made and reported policy issued by Lloyd's to the plaintiff. The court found plaintiff was not entitled to coverage and granted the motion. In CMGK versus Lloyd's, a Superior Court of New Jersey Appellate Division decision of June 13, 2024, the appeal was considered based on the facts established by the motions. CMGK operated a Massage Envy spa franchise located in Mays Landing. Emad Gus Khalifa was the sole member of plaintiff and was familiar with its operations. In 2023, plaintiff hired April Pippin as general manager to assist Khalifa with the day-to-day management of the facility. Pippin and Khalifa performed management functions for the plaintiff. Khalifa executed on behalf of plaintiff an application for the policy at issue, which stated, quote, "This claims-made policy applies only to those claims arising from covered incidents which occur on or after the stated retroactive date. In addition, the claim must first be made and reported to the company during the policy period or applicable extended reporting period." Defendant issued its specified medical professional liability insurance policy to the plaintiff for the policy period March 9, 2018 to 2019 and subject to a retroactive date of March 9, 2014. The policy included a sexual acts liability endorsement, which prior to the effective date of the policy, the insured represented in an application that it had no knowledge of a sexual act of any fact, circumstance, situation, or incident involving a sexual act which may result in a claim under the policy. However, in 2016, plaintiff hired Stefan Davis as a massage therapist. According to plaintiff's client, M.N., Davis sexually assaulted her during a massage he performed on her on December 23, 2017. 2 days later, M.N. reported the alleged assault to Pippin. On September 26, 2017, M.N. went to the Township of Hamilton police station and told a police officer about the incident. According to the officer, M.N. told her Davis had placed his finger between her vagina lips and cupped her breast during a massage. M.N. eventually sued, even though there was never an arrest. On September 5 of 2018, plaintiff tendered the suit to defendant for coverage, who refused to defend or indemnify the plaintiff, who then sued Lloyd's, claiming Lloyd's had breached the policy and seeking a judgment declaring M.N.'s claims fell within the coverage provided by Lloyd's. finding the language of the prior knowledge clause to be clear and unambiguous. The trial court rejected plaintiff's attempt to interpret it in a manner where an honest belief in the futility of a claim negates actual knowledge of allegations of wrongdoing. The court found that the police decision not to file criminal charges did not support a reasonable belief that MN would not file a civil lawsuit. Khalifa's assumption, or hope, purportedly based on the officer's decision not to file a criminal complaint or MN's decision not to file a civil complaint sooner, that MN wouldn't file a claim is not enough to defeat summary judgment. Adopting plaintiff's interpretation of the policy language would have the effect of rendering meaningless the prior knowledge clauses. To avoid the application of the clause, an insured could simply assert it did not believe. In the face of all evidence to the contrary, a claim might be filed. The reasonableness of excluding claims based on prior conduct that the insured could reasonably have foreseen might serve as the basis for a future claim was apparent to the appellate court, as it could be to anyone involved in the business of insurance. The appellate division, therefore, affirmed the order granting defendant's summary judgment motion. In my opinion, an application for insurance is a request to an insurer to make an offer of insurance. The insurer relies on the good faith of the proposed insured to accurately respond to all inquiries, including any information available to the insured at the time of the application is presented, of any acts that could result in a claim. Such an act, sexual abuse of a customer by a massage therapist, known to the insured but not yet grown into an actual suit, must be disclosed to allow the insurer to make a well-reasoned decision to offer or not offer to insure the proposed insured. By keeping it secret, the insurance was issued and the insurer was deceived. This video was adopted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also have access to the more than 4,800 blog postings. You can also subscribe to these videos on rumble.com or youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on rumble.com and the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.